Hello and welcome to our webinar this evening. The webinar here is to support you to get your child's support back in place after schools reopen next week. I'm Tanya Tiraoro.
And I'm Renata Blower, and we are the co-directors of Special Needs Jungle. This
And
webinar was suggested following the publication of our report, Provision Denied. Our report illustrated how, the last time children went back to school in September 2020, many disabled children did not have their SEND position reinstated. In some cases, children were not allowed back in school at all, despite the Children and Families Act being fully back in force. We found that
nearly 2/3 of parent carers of learners with EHCPs reported that their child's legally binding provision hadn't been fully restored, and that fewer than 1 in 5 parents explicitly confirmed that all their provision in their child's EHCP had been fully restored. Most people were not even sure.
speech and language, occupational therapy and hydrotherapy that were normally delivered by NHS professionals were most likely to not be back in place. For those children without an EHCP on SEND support, just 8% of parents and carers confirmed that all provision their child had had a year ago was now back in place. Almost 3/4 of these said that some or all of their child's teaching assistant support had been withdrawn.
So we made 45 recommendations, including 8 for the Department for Education. We do know that the DfE has read the report, and we hope you can help us get these recommendations out by passing on our report to your child's school, local authority. And you can find the report from the link at the top of the specialnewsjungle.com website.
So, as we said, having read our report, public law barristers Alice Irving and Steve Broach, who most of you here this evening will have heard of, were very concerned and wanted to do something practical themselves to help.
So we've teamed up with Alice, who's from Doughty Street Chambers, and Steve from 39 Essex Chambers. And we've also roped in 2 expert SEND solicitors, our own legal columnist, Hayley Mason, who's the director for SEN Legal Limited, and Gregg of the charity Coram Children's Legal Centre.
We're delighted that 4 fine legal minds are with us this evening to lend their SEND expertise to help you make sure that both your child's support and their placement is back in place.
So we're now going to hand you over to Steve Broach, who is going to be chairing the webinar, and we'll see you all again at the end. So over to you, Steve.
Thanks so much, Tanya and Renata, and good evening, everyone. Welcome to this Special Needs Jungle webinar. We're absolutely delighted to have put this together for everyone and to have so many people joining us this evening, and the webinar should be recorded as well and available through Special Needs Jungle shortly afterwards. We've had lots of questions come in advance, and we want to give as much time as we can to ask people to ask and answer questions. And people who haven't used Zoom before, that you should be able to see in the menu bar a Q&A function. I can see someone's already managed to ask a written question, which is great. So please do ask questions there. However, just to be clear and to perhaps to interrupt, we can't give any case-specific advice tonight. So please do try and keep the questions short and general, and then we'll be able to answer them. And one of the things we'll be talking about, of course, as we go through this evening is, well, how do you get the advice that you may well need? I found the results of the Special Needs Jungle survey not surprising, but profoundly disappointing, because Alice and I were involved in the legal challenge that took place in the summer of last year to try and get the duties, the core duty in relation to education, healthcare and care plans reinstated, which happened not as a result of the legal case, but because the Secretary of State decided to put the law fully back in force from August. And yet, despite that, we know that so many children and young people with SEND were not getting the provision that they needed, and in some cases that they had a right to under their EHC plan. And so we need to bridge the gap between the law and the reality and practical experience that children and families are having on the ground. And so that's what we're hoping to do in roughly the next hour or so tonight. And so the running order for the lawyers this evening is that Alice is going to go first to talk about the law in about 10 minutes. And then Hayley's going next to start looking at some of the practical ways in which children, young people and parents can enforce rights. And then she's going to segue into Gregg's talk, which is going to be more of the same, but with a particular legal aid flavour, because we're very lucky to have with us a senior lawyer at one of the two main legal aid providers in this area, Coram Children's Legal Centre. So all those questions you wanted to ask about how legal aid works, poor Gregg is going to have to try and answer them for us. And I might even ask some particularly nasty ones to him later. So that's a coming soon. That's the perhaps the star attraction at the end. But not to be outdone, I'm going to start with Alice, who has been working with me on lots of very interesting special educational needs cases. Is a barrister at Doughty Street Chambers and is going to very kindly take us through the headlines as to the key legal duties, both in terms of EHC plans, but also for children and young people with SEND, but who do not yet at least have an EHC plan. So over to you, Alice.
Great, thanks so much, Steve. Exactly.
I'll stop sharing my screen. You should be able to share your slides. There you go.
Excellent. So I do have some slides, and I'm going to give you a whistle-stop tour of the legal duties that are in force, with, I think, the practical part of the seminar basically being most helpful to you. When it comes to the legal duties, if the child or young person has an education, health and care plan, then the headline here is the duty that I'm sure many of you are familiar with in Section 42 of the Children and Families Act 2014, remains in full force. So it was the case in the lead up to the summer last year that the duty to secure the provision specified in an education, health and care plan was downgraded under the coronavirus legislation to a duty to use reasonable endeavours, and that was the case for a number of months. But the duty has been in full force since August of last year, and so it is the case that a local authority must secure any educational provision in Section F of an education, health and care plan. And similarly, the responsible commissioning body, most likely the clinical commissioning group in a local area, must arrange any healthcare provision which is specified in an education, health and care plan. And this is must. There's no reasonable endeavours. There's no we try our best. It's an absolute duty. And one of the things that came out of that case that Steve and I brought to try to challenge the downgrading of the duties, which wasn't altogether successful, but there was a very useful statement actually from the court there saying that Section 42 is an unqualified duty. So it's not good enough if a local authority or a school is saying to you, well, we can't because of COVID in relation to provision, education, health and care provision in a plan. If they say, oh, we can't because it's COVID or it's too hard, that's not in line with the legal duty. The legal duty is a must if it's stated and set out in the provision of the plan, if it's in Section F, if it's in the healthcare section, there's a legal duty to provide it that's absolute. And also just the other important duty, obviously, is that under Section 43 of the same legislation, if a school is named in Section I of a child's education, health and care plan, then they have a duty to admit that child. So for children who don't have education, health and care plans, there are still really important duties in the same piece of legislation from 2014. Section 66 is the duty on either the governing body or the proprietor of a school to use best endeavours to secure the SEND provision that a child needs. And when we say best endeavours, that's stronger than the duty reasonable endeavours. It's not enough to just sort of do reasonably what they might be able to do. They have to really try hard. And so it's not an absolute duty like Section 42, but it's still something you can hang your hat on. And Section 100 provides as well that the school has to make arrangement for supporting pupils at school with medical conditions. There's really useful guidance that adds and expands on what schools should do in supporting students with medical conditions. And sort of the key headline bullet points from that, and I'll make sure these slides are available when SNJ posts this, is that you should be supporting children to have full access, so the governing body should be doing that, and also there should be consultation to figure out how to make sure that that is done. And so again, we shouldn't have things happening unilaterally without discussion with parents and other healthcare and social care professionals. It's always worth thinking about the Equality Act in this context. I think the headline for the purposes at present is that if a school adopts a particular policy, so they say, well, you can't come back to school unless you can do X, and that disadvantages a disabled person, say, you know, you can't come back to school unless you can carry out a coronavirus test. It might be, and it probably is the case, that if that substantially disadvantages the disabled person, then the school has to think about making a reasonable adjustment. So what could we do differently in order to accommodate a disabled person? It's going to be very case specific. So if you have an issue like that, you definitely need to seek some advice. There might also be other discrimination angles in any given case. There is COVID guidance up specific to schools. So any child with an education, health and care plan is classed as vulnerable in the relevant COVID guidance. And therefore, throughout lockdown, they ought to have been able to attend school on a full-time basis. And I know that that's not been the case for many children with education, health and care plans. In relation to special schools, from the 8th of March, school attendance is mandatory unless an individual is shielding. So they're still on the shielding list, which is very few individuals at this point, or for example, they have COVID symptoms. So attendance is expected from the 8th of March. Where remote education is what is being provided, for example, because a school is locked down because of some breakout at school, schools should be working to provide reasonable adjustments to, as far as possible, make that accessible to a disabled student. So again, if you're not getting differentiated content, or you're getting you know, website stuff that you can't really use, or your child can't really use, that is something that's not in line with the government guidance. And in turn, when it comes to that core duty to provide educational provision, there's a recognition in the guidance that sometimes it's going to be hard to do exactly what it says in the education, health and care plan. But the answer to that isn't that the school or the local authority should throw up their hands and say, too hard, can't do it. They should be co-producing alternative arrangements for delivering provision. And they shouldn't be taking a one-size-fits-all approach. So they shouldn't be saying to all of their students with SEN, or even with particular types of special educational needs, we're going to do X, or we're going to deny you provision. They're meant to be in conversation with parents and young people to try to figure out what they can do to put in place provision. And again, we know that that's unfortunately often not happening. Really importantly, right at the beginning of the pandemic, I'm sure that many of you experienced the risk assessments that were linked to many vulnerable students and students with special educational needs. Those should not be being used as a justification for refusing attendance. So a school shouldn't be turning around and saying, we've risk assessed and we've decided that your child can't attend. That again is not in line with government guidance. And again, if a child is able to attend school, and there are questions about whether or not the usual intervention or staff ratios are available, so maybe they don't have all of the staff on the rota to do the one-to-ones they would normally do, the guidance is very clear that this should resume as quickly as possible. And again, it's not really good enough on an ongoing, sustained basis to say, sorry, COVID's really hard, we've got staffing difficulties, end of story. So I've got some links there to the key guidance, which are constantly being updated. So do bear in mind that everything I've just said is subject to the normal COVID caveat, which is things move quickly. I think really what matters is the legal duties are fairly clear. What's happening and what's been found in the survey isn't lawful in terms of students being refused access to schools and being refused provision. The question then becomes, well, how do we use these clear legal duties which say that provision should be in place and students should be able to go back to school? How do we use that to make sure that you know, these things are actually happening? And so I'll hand over to the very experienced solicitors we've got on the panel to start talking about those practical issues.
Thank you so much, Alice. That was a fantastic whistle-stop tour, but I'm going to jump in and abuse chair's privilege, and sorry, Hayley, to cut across you. But, there are some pure legal questions that I think are quite important I'd like to put to Alice first of all. So you're going to have to unmute yourself again, Alice, I'm afraid. You're not quite off duty yet. The first of them is quite an important question, I think, which is, who is legally responsible for making sure that the provision in EHC plans happens? Is it schools or local authorities?
Local authorities. So in relation to the educational provision, it's the local authority. In relation to the healthcare provision, it's the relevant commissioning body, probably the clinical commissioning group. But importantly, if a school is not doing something appropriately, and you've raised it with the school and they're not doing anything, and the local authority is sort of trying to push back and say, well, we're just relying on what the school says, that's not good enough. The buck stops with the local authority. That's what the legislation says, and you can go to them and say, look, you need to do something about what the school is doing to sort this out. They're not allowed to just defer to a school in their judgment.
That's quite an important point, isn't it? Something we should perhaps pick up with Hayley and Gregg as well, that it's the local authority that has the duty, even if it's the school that's got the child, which does create some real challenges from time to time. But another important legal question, Alice, what about annual reviews of EHC plans? Because of course the law was also eased in relation to the process for EHC plans, including the annual review duty. Is that now back fully in force?
Yes, it is. So there was an easing of all of the timescales in which local authorities could comply with various steps, but that all expired on the 25th of September last year in terms of any changes under the COVID regulations. So we're back to what was enforced before the pandemic came along. Annual review should be completed, well, annually, since the last finalised plan. And within the review process, there are specific timelines for each step in that process. So if you've got concerns that something's taking a really long time, so maybe you've had a review meeting, but you've not seen anything or heard anything since, that's a good time to maybe seek help and to see if the local authority might have breached a time specific duty there, and that you can start sending them letters to try to hurry them up.
That would be a good point to move on to Hayley. But just before we do, is it now fair to say that all the law is back as it says it is in this wonderful book?
Yes, Steve.
Leading question. So everything, as far as we know, that was in place before the pandemic, when we published this in January 2020, it's like a lifetime ago, is now exactly as it was. That's right, isn't it? None of the changes that happened in the first half of last year are still in force.
That's correct. And I know that local authorities and schools are still saying that things are different, but that isn't true.
Yeah. Well, thank you very much, Alice. That's a perfect segue into Hayley's talk, I think, because what do we do, Hayley, when local authorities and schools say things that might not be an accurate reflection of the law? How do we ensure that these rights that are now back fully enforced are actually realised for children, young people and families? 10 minutes, please. Over to you.
Yes, just to warn you all in advance, Steve has obviously listened to me speaking previously, so I have a very short 10 minutes that he's holding me to account for, so apologies. I will try to be as quick as possible. I do love speaking with parents, so I will try to keep it sweet. In terms of the parents dialing into this webinar, I know that you will be on different journeys. Some of you will have EHC plans and some of you won't. So I think the first thing that we need to identify is actually where you are on that sphere. And the first question to then establish is, does your child have an EHC plan or do they not? And that might seem like a really simplistic question, but because every local authority area have EHC plans that look very different, and also some local authorities have additional plans that aren't EHC plans, I think sometimes parents can actually be very confused whether or not their child actually has a plan in the first place. So if you have an EHC plan or you don't, that's the first thing to establish. If your child doesn't have an EHC plan, you are in a less protected position. I think I can be accurate in saying that, because the good thing for parents to know in this area of law is very much that your rights are protected. It's one of the great areas of law where actually the law is very clear. The problem is that local authorities often don't follow the law, and obviously then you arrive with someone like me to actually challenge what they're doing. So if you don't have an EHC plan and you are perhaps getting SEN support or just some additional support from the school, lots of schools go out of their way, I know, to put some additional support in place for a child, whether that's funding some additional one-to-one support or giving some direct tutoring, then you really need to be speaking to the teacher, speaking to the SENCO, and actually seeing what additional support that your child might actually need when they return to school. Understandably, all children are going to be anxious returning to school. And if you can work with the school to get the provision in place and know what's going to be happening when your child goes into school, particularly with SEN, if you can get some visual timetables and some social stories to prepare them for that, that would obviously be really excellent. You then need to ask yourself a question if you don't have an EHC plan. Well, actually, is this the time when you start looking at perhaps an EHC needs assessment? I know from my work with Special Needs Jungle and also my work in private practice that many parents have actually identified, particularly during homeschooling, like many of you have been diligently trying at home, and take my hat off to all of you who have been homeschooling in this difficult time. Many parents have actually noticed some additional needs of their children. So perhaps you think, well, actually, my child was getting a little bit of support at home, and now we need some additional support, and you might need to consider an EHC assessment at this time. If, however, you do have an EHC plan, like I said, your rights are very well protected, but what you need to first identify is exactly what's in the important sections of that EHC plan. Because the key educational sections are sections B, F, and I. So section B should very specifically detail what your child's needs are, and section F should set out exactly what support they require. And sometimes there is some confusion where parents think that support is not in place for their child that should be on reading their EHC plan. And that's really when it comes down to the specific wording of the plan. Because if your plan, for example, says in section F, Charlie would benefit from one-to-one support, that isn't quantified. So if you're returning to school and actually the school are even offering 1 hour of support, arguably that is one-to-one support. So it's really looking at the quantified wording in section F. Have you got a specific amount of hours for one-to-one support, or speech and language therapy, occupational therapy, etc. So I start with that hedge note of actually looking at what you're entitled to make sure that it's not being delivered in the first place. If you then think, well, actually my wording isn't specific in my EHC plan, and I do need to look at this, there are multiple ways you can do so, and the annual review is probably the easiest one. And like Alice has said, annual reviews are very much in force and should be happening every year. So any EHC plans that haven't had their annual review within the last year and you are over that 12-month benchmark, like many parents will be shouting at their screen, all of us, Hayley, we're all waiting for them, you can legally force them to take place. They have to take place within a year. And this is done quite simply by sending a pre-action protocol letter to your local authority, which I'll touch on again in just a second. So similarly, as Alice has just touched on, when you have quantified and specific wording in sections B and F of an EHC plan, section F is the main thing you should be focusing on, because that is exactly what should be being delivered and must be delivered in law under your child's EHC plan when they are at school. So if any of that isn't being delivered, the first thing that you should probably do from a practical example is actually consider, why isn't it being delivered? Because if this is just something short term where everybody's returned to school, the school is still figuring it out, and it's just going to be a week and then something's going to be back in place, you might not want to challenge it down the legal route because there is going to be an outcome very shortly for you. If, however, it's the case that the school doesn't have enough funding or therapists aren't available, etc., then you might obviously need to look at a legal challenge. So what a must duty means in law is that it has to be provided. And I know from all of the risk assessments and the way that they've been incorrectly used and the work that I do with Special Needs Jungle, this isn't happening. Lots of schools are saying people can't return to school, or that if they return, they're not going to have their one-to-one, they're not going to have their speech and language therapy, and that's actually unlawful behaviour. So what we can do is, similarly to the annual review, and if section F isn't being delivered, it's the same route of redress, so the same solution in essence. We firstly establish how long it's going to take, and then what we actually do is we write to the local authority, because as Alice just touched on at the end there, it's the local authority's legal duty. And I hope that will be some reassurance to any schools that are watching, because many schools obviously get hit with the anger from, rightly so, from parents who want the support in place, but it is actually the local authority's legal duty. So what we would be looking at is writing a letter to the local authority to make them aware, and also give them an opportunity to resolve this informally, get the provision back in place, let them speak to the school just in case there is a breakdown in communication. And if there is not a breakdown in communication, it is in fact the whole point is that actually provision isn't being delivered, we can write what we call a pre-action protocol letter. And it's essentially a letter that goes to the local authority and their legal team and points out their legal duty and the issue of your case, in essence, the facts of what's going on, and that they are not fulfilling that legal duty. And that is the first step before a judicial review challenge. Many, many, many cases, I could count on one hand how many cases I've had to take all the way through to a judicial review. So many of them resolve themselves on these pre-action protocol letters. So often is the case, this pre-action letter goes, the local authority read the letter and think, oh, oops, we've done that bit wrong. They put the provision back in place. If that isn't the case, you would need to proceed with a judicial review claim. However, if you're going to proceed with a judicial review claim, you should always take legal advice. And that is why you are blessed on the webinar this evening. I obviously only specialise in private practice. I am a senior solicitor at SEN Legal, so we don't actually do legal aid. But the fantastic Gregg is going to be following on from my talk, and he will be able to give you all of the information that you need about legal aid. So if you can't afford private legal services, which I know not everybody can afford, Gregg is definitely your man who will talk you through everything that you need to know. So in terms of practical steps, the first thing is to establish what you're allowed access to. Do you have a plan? Do you not have a plan? Try to resolve it informally if you can, but don't wait weeks, don't wait months. The legal duty is there to protect you and to ensure that your child has the right amount of support. So if this is delayed even by 2 weeks and you need an answer, you're well within your legal rights to write to the local authority and also to send that pre-action protocol letter, because it is a legal duty and there is so much misinformation out there for parents, hence why we're holding this webinar, so that you're absolutely clear on what should be being delivered. So speech and language therapy, occupational therapy, one-to-one, all of that support, physiotherapy, etc., should now be in force, and actually should have been enforced since September. So many local authorities have got away with it for a long time, Steve. But without further ado, just because to give the differentiation, unless you've got questions, I know we're going on at the end to questions, I'd like to hand over to Gregg to do the legal aid route, unless you've got a few.
Yes, I'm going to jump in again, Hayley. I can't resist. I'm sorry. I want to put something to you that's very much based on the kind of practicality and the pragmatic approach that you've been talking about. Question that we've had is, what about if actually making the provision is genuinely impossible for the school? For example, most of the staff are ill or self-isolating and supply teachers can't be accessed. What would you do in that situation where it's not a failure to use best endeavours, it's simply that they can't do it?
I'd write to the local authority, because again, this is the school that can't deliver it, but the local authority can obviously call on all of their resources. So if it can't be delivered in the school from the resources available, they need to look elsewhere for it. We know it's quite common that actually independent practitioners are pulled in. If, for example, the NHS therapists can't deliver therapy, and many therapists do so, and also they can pull into, they've got wider resources, local authorities. But the challenge there is not with the school, it is with the local authority.
That must be right, mustn't it? There's some very helpful case law on this, I think, which says that there's no best endeavours defence for not delivering what's in a plan. But equally, of course, if it's impossible, the courts aren't going to order it. The courts don't go around ordering public bodies to do things that are impossible. So, so my advice in those cases has always been, well, how is it just really difficult, or is it actually impossible? So, for example, if the parents agree the child can't go to school, they can't have the provision that's in the plan that talks about the child working in a small group in school with their peers. Those two things are incompatible. But if the provision that's in the plan includes an hour a week of speech and language therapy, then that should be delivered in a different setting.
I mean, that can be delivered virtually, can't it? If the child can access it virtually. you can very easily amend it that way. And that's what happened through certainly the first lockdown. Everyone got very creative. And I feel that there was a big group of parents that unfortunately their local authority and schools just didn't move with that, because we saw some really creative input from a lot of schools and a lot of professionals in order to deliver that therapy.
There's a huge amount of variation, wasn't there, in practice? Perhaps the pandemic just exacerbated what was already a very significant variation. But I agree, there was some brilliant creativity, and then lots of no, we just can't do that without really that much thought, unfortunately.
Yeah, definitely.
Thank you, Hayley. We'll definitely be coming back to you for some more tips in general questions shortly. But yes, I will now, without any further ado or too much pressure, hand over to Gregg. And what we particularly wanted Gregg to help us with was how to access legal aid. And perhaps just to set that up, of course, there are two real legal remedies available to families in the SEND area. One is the tribunal, which is about disputes in relation to whether the child is going to have an EHC plan or what the plan says. But that's it, in essence. The tribunal doesn't have any wider jurisdiction. And so on other issues, and in particular, non-delivery of provision in the plan, or perhaps it might be a general failure to educate, the remedy will be judicial review in the High Court. And so, Gregg, not only have you only got 10 minutes, you've also got, if that's okay, to try and talk about two quite different legal processes and how people can get legal aid for both the tribunal and judicial review. Thanks very much.
Steve, hi, thank you very much. Firstly, thank you to Tanya and Renata for inviting me tonight. I'm very privileged to be in such esteemed company, and thank you very much for tuning in. So as Hayley, Alice and Steve have previously said, we are on a tight schedule of 10 minutes. So forgive me if I speak slightly quicker than I normally would, but in terms of just getting information and that access to be able to exhaust all the options to get the provision required for your child or young person within that EHCP, what I've particularly looked at is how do people get a legal aid provider? Can they contact that law firm directly? So the starting point for legal aid for education law is in fact the Civil Legal Advice Helpline, the CLA helpline. Now that's a telephone gateway service that allows parents of children and young people a way to determine if their education problem is in scope of legal help, which is a type of legal aid. Perhaps the slower style now talk is to tell you what the telephone number to call is. So that's 0345 345 4345. Lots of zeros, threes and fours and fives there. So that number again, 0345 345 4345. Now it's a helpline that's open from Monday to Friday from 9 AM to 8 PM. And also on a Saturday between 9 AM to 12:30 PM. So I think it's deliberately gauged to be available after normal working hours. Now, as Steve helpfully pointed out, not all matters are in scope, but the failure just on that point, the thin end of the wedge really, in terms of what legal help and legal aid can provide, the failure to deliver special educational provision in an EHCP is in scope. So you would have to satisfy the merits test. Now there are two tests. There is a means test and a merits test to pass. And this is for legal help. So when you call the number, there is an initial triage to make sure that you would initially pass the merits test for that education law matter. And then you'll put through to a legal advisor in one of the two contracted providers, either Simpson Miller or Coram Children's Legal Centre, CCLC. When you initially make the call to the CLA helpline, you would need to show either that you are eligible for that legal help through your finances, or potentially your child or young person might be eligible if they're over 18, or in some cases between the age of 16 and 17 and live with you. So you would need to have certain things to hand when you call that number, such as proof of any welfare benefits that you can rely on, pay slips if you work, and also bank statements as well. Just a side note for further information on legal aid eligibility, you can actually look online for the legal aid eligibility calculator, quite a mouthful. So if you just Google legal aid eligibility calculator, then you should be able to find it and put in some cursory figures. A benefit so start again, Greg. There are certain benefits that would entitle you or passport you or your young person, if they're over 18 or in receipt of those welfare benefits. So they're a whistle-stop tour. They will be universal credit, income support, income-related employment support allowance, income-related job seekers allowance, and the guarantee element of pension credit. So those are automatically passporting benefits. So we're now looking at the means test as well as the merits. But I think if you mention about the failure to deliver special educational provision in your child's EHCP, when you initially call that number, I think that should be sufficient to get you through that initial triage, which will then get you through to Simpson-Miller or CCLC respectively. When you do get through to one of those two providers, you can now also request a face-to-face appointment once you're put through. So there are now actually more law firms who provide face-to-face appointments. You've got Coram and Simpson-Miller delivering the remote advice. And if you were to say to them, look, I actually think I would benefit from a face-to-face appointment here. I believe there are 8 national law firms who now offer face-to-face appointments. And again, if you just Google that legal aid finder, and tick the box for education, then it should give you a drop down of the 8 providers, and it will tell you the distance relative to your postcode. And I do have those names of those law firms if it would help perhaps at the end. Just a point to note, one thing that I initially spoke to everyone slightly before we came on the call live was I don't quite know how those face-to-face providers may actually be delivering the face-to-face contract at the moment through the current pandemic, and if they're actually undertaking it through appointments, for example, remotely, Zoom, or if they have capacity. If you were to find, I think, that they don't have capacity, then I think you can actually come back through the CLA helpline to have that telephone advice, which will enable you, which I'll come on to open that legal help file, but at least then you've exhausted the opportunity of having that face-to-face appointment. Conversely, if you're happy to have that problem explored through the initial call, sorry, I do appreciate I'm talking very quickly, then you just continue with the initial conversation. Once you've explained your education issue, I think the next step would be to send out what's known as a legal help form for you to sign if you're eligible in terms of the means and the merits test, or conversely, if you're looking to put the legal help file in the name of your child who may themselves be eligible in their own right, by way of those passported benefits that we've spoken about earlier, or in terms of the disposable income they have per month, that needs to be set at, it needs to be lower than a certain number, and potentially if you are over a threshold, if you or your young person simply earn too much money relative to what the legal aid agency prescribes it as, then you wouldn't be eligible. But let's suppose that you are, and that you then return the legal help form with proof of eligibility, the bank statements, for example, the Department for Work and Pensions benefit award letter you might be in, any wages, for example, wage slips. Once the forms are returned and it's been verified you're eligible for legal help, then your case is allocated to that legal advisor. And that's when the full sort of substantive work can then begin. So if you or your child or young person are eligible under that legal help scheme, then as Hayley has very kindly and politely touched upon, I mean, it's how we can get that pre-action protocol letter sent out to the local authority, in this case, looking at it thinly for that failure to deliver the provision in section F, the education provision of your son or daughter's EHCP. If it transpires that you go through that CLA helpline and you aren't eligible, then there are other avenues, as you know, we've spoken about, considering paying privately for the letter before action correspondence, in this case to the public body, which would be the local authority. But let's suppose we now get to the stage where you've instructed another law firm to send that pre-action letter under the JR protocol. But for whatever reason, as Hayley has sort of touched upon, it hasn't resulted in the provision being delivered for your child or young person, and you'll now resolve to move things forward to the next step. You've given them that opportunity to put things right, as Hayley said, and I echo what she said, the amount of pre-action letters that you send actually prior and then issue, normally it tends to remedy the situation quite quickly when the threat of legal action is upon the local authority. We would then need to look at making an application for a public funding certificate if we've sent that pre-action letter and that hasn't done the job. Now that's different to the legal help, which is how we actually get to the pre-action stage in terms of eligibility for means and merits. But the public funding certificate, looking at that now, where you need to obtain funding to move to a claim for JR, I think you would need that advice really, that there is a realistic prospect and it's merited, frankly. A public funding certificate would normally be for the full representation, and you would have that monetary and also a scope limit from the legal aid agency on the work that can be conducted under this public funding certificate or legal aid certificate. Now, your solicitor would need to have that legal aid contract. They would need to be the ones making the application to the legal aid agency through an online system called CCMS. And again, it's subject to that means and merits test in order to obtain that. Generally speaking, you would need to satisfy the legal aid agency that you have at least a 50% prospect of success of obtaining the outcome that you're hoping to achieve from the judicial review, which in this case is ensuring that the provision written into the EHCP is in fact delivered by way of that judicial review. And I must say, and I appreciate we'll probably get onto this maybe with the help of Alice and Hayley and Steve later, but any remedy from JR is discretionary. I think it's important to note that in the circumstances of failure to deliver the provision in the EHCP, that you can make what's known as an emergency application for funding to the legal aid agency. So you're basically saying, look, we've exhausted the avenues, we've tried our best, we've written to the public body, in this case the local authority, and we've told them what unfortunately hasn't happened. We've given them an opportunity to put it right, and we're still where we started 2 or 3 weeks ago prior to sending that pre-action letter. If you make the emergency application to the legal aid agency, I think I'll stay LAA in future so as to because it's a bit of a mouthful. You could usually expect a decision on whether or not the emergency certificate would be issued within 72 hours, I think it is. So you would really need to be alive to that and make sure that your instructed legal representative is really chasing the application after it's made. Also a law firm with, and this ties in slightly to what Steve asked me about initially, a law firm with a public law contract could also make the online application through CCMS. It doesn't necessarily need to be one of the 8 firms that I've touched upon earlier. One thing to note though is that the law firm or charity, for example, who may have that legal aid contract to deliver that under the public law heading would actually need to be au fait with education law in order to, I would say gently, in order to make the application, so that they have the sufficient knowledge and capacity to actually run that judicial review. Now, lastly, one of the other questions that I was asked to consider was, when can legal aid be obtained solely on the basis of the child or young person's means without potentially the parental means being taken into account? So turning to Alice, actually, Alice, I've got written down here that you and I have actually run a few, or certainly one judicial review claim under a public funding certificate. And in that instance, we showed that we tried to exhaust all of the other avenues before getting to that stage. And the claim for permission, as I said, JR is a remedy of last resort. So in that instance, I think it's prudent to obtain a barrister's quick advice on the merits of the claim beforehand to satisfy the legal aid agency to show that they're at least 50% of achieving what we hope to achieve, which would be the LA to deliver that provision. In our example, we made the application in the child's name as they would be the proposed claimants, and they are the person who is having the unlawful failure done to them, if you like, which would be the lack of provision in the EHCP. So this would mean that it would be possible for the child's means to be taken into account for the purposes of the means test without the parental means being considered. If your child conversely is over 18, then my understanding is it would be their means that would be assessed as the proposed claimant, and they may well be in receipt of a welfare benefit that might passport them to satisfy the means test, or you might have to undertake that detailed means assessment looking at their income and also their capital as well. So if they have savings, for example, or trust fund, that would also need to be considered. The last 2 points I've got, the means assessment for a public funding certificate, they are detailed, too detailed I think for this initial talk, but there are lots of questions that your legal aid or the instructed representative would go through over the phone with you, filling out that application online. There are capital and savings thresholds. It may be that the legal aid agency would ask you to make a one-off monthly contribution, a one-off contribution or a monthly contribution. So that's something to be aware of, and but it would depend on things like your savings, or if your child has savings. So I appreciate that's a lot of information. I've probably gone over the 10 minutes, so I do apologise. About legal help and legal aid for a public funding certificate and how it could be funded for that judicial review claim. But you would need the expertise of a barrister and an education lawyer to run the claim. So I hope that helps in some way, and I'll certainly defer back to Alice, Hayley and Steve's expertise now.
Thank you very much, Greg. Just a couple of quick questions to pick up points that you've made. First of all, it's right, I think, for the tribunal, you can only access legal help, isn't it? So you can only get that initial stage of advice. You can't get full representation in the tribunal. Is that right?
Thank you, Steve. Sorry, that's one thing that you initially asked me about and I completely disregarded, so apologies for that. Yes, the short answer is yes. Legal help, I think I said not all matters are in scope, but under education law, well, the SEN tribunal, running an SEN tribunal from start to finish is in scope, so from actually lodging the appeal. But you're right to say that it doesn't include tribunal representation. Unfortunately, that isn't in scope, but the legal help scheme does fund all the way up to representation.
And it does. Yeah, sorry.
Sorry, no, go on, Steve, because I think we're probably about to say the same thing.
Well, it does cover reports, doesn't it? Which I think is quite important in the tribunal claim. That was the point I was going to make.
Thank you. You're absolutely right. So it is really, without denigrating the local authority too much, sometimes we find that, and maybe Hayley will agree with this, but you find that you actually have to do the job of the local authority for it by obtaining those professional reports. That's not a criticism, just an observation. Now, the legal help scheme for SEN tribunal appeals does incorporate that. So yes, you can have those private or independent reports such as speech and language therapy, occupational therapy, educational psychology, physiotherapy, miscellaneous therapies as well may fall under it, so apologies if I haven't covered those. But yes, independent or private reports, it's known as a disbursement under the legal aid agency, and you would need to have a legal aid agency supervisor who's effectively approving the merits of that report being commissioned, but that would flow into the SEN tribunal as part of the final evidence.
In terms of judicial review, then you've got access to legal help if people are eligible, and my understanding of the way it works as a barrister is that if you're dealing with a child who's not being educated, for example, in accordance with the EHC plan, the parents' means are taken into account at that stage when you're looking at whether you can get legal help to do the initial work. But then it's possible, at least, that they won't be taken into account at the stage where you need to get the certificate to go to court, the full representation certificate. Is that right? As a summary.
Thank you, Steve. Sorry, yeah, I don't know if anybody else is having slight trouble. It's hopefully just my computer, but I heard there that yes, so legal help you would need to take into account in certain circumstances the means of the parent, in the case of the child, for example, but if there are law firms who have that public law contract or education contract to then run an action against the local authority as that public body as part of legal aid, then it's not necessary in every case to take into account the means of the parents. You can put the legal aid certificate in the name of the child or young person as long as they are financially eligible.
Okay, thank you so much, Greg. So I think I'll bring everyone back in now if I can for general questions, and perhaps to then ask the obvious question of all of you, which arises from Gregg's talk, is, well, what happens if you're just not eligible for legal aid, if you can't get the right legal aid that you need? Obviously, some people will be in a position to pay privately for legal advice and support. For those who can't, some thoughts I've had, and then I'll open up, please, to colleague chair. First of all, there are, of course, some brilliant charities working in the SEN space, SOS, SEN, IPSI, amongst others, who, and I know that SOS, SEN offer a discounted fee for pre-action correspondence, because several of the questions have been, well, can I just send my own pre-action letter? And several problems with that. First of all, of course, what's it going to say? You need advice about the content. But even then, a letter that's sent by a parent themselves is frankly not going to have the same kind of weight as a letter sent by a specialist legal agency, because the local authority won't think that it's going to result in them being taken to court. So it really is important, I think, to get advice, but also for the letter to be sent with the right headed paper. The charities, of course, have got limited capacity. So one other thing that the people have been doing increasingly is crowdfunding, using the Crowd Justice website to try and fundraise perhaps the early stages of work before you can then apply for a legal aid certificate. So I think Crowd Justice and other crowdfunding sites are an important part of the mix. So those are two thoughts. I don't know, Hayley, what would you do with clients who are not really in a position to pay, but of course sadly fall into that gap where they can't get legal aid? What help can you suggest for them?
Similarly, Steve, if they obviously can't get legal aid and they do fall into that kind of grey area, many firms, I'm sure, like our firms, we're tailored so that we do offer different price points for all different seniority of solicitors. So there generally are options at firms, particularly if you're just coming for kind of an initial pre-action protocol letter that's likely to resolve the problem. Then that is kind of a one-off piece of work. And I know many firms will be hopefully the same as that. In that grey area, however, like you said, there are the charities. Another one I know of, if parents are in, or not even, with the world of COVID and everything going virtual now, but for autistic children, I know of Hillingdon Autistic Care and Support. They're another charity who have kind of a membership scheme, and they help parents prepare tribunal paperwork. They're not legally qualified, but they certainly turn up at tribunals and support parents. And there are many other charities that do the same, but that's one I've also worked closely with, and we deliver lots of free webinars for them and support for them as well. If parents are doing it themselves, I would say to certainly do your research. There are so many free resources now available online, particularly around this field. I know obviously Steve's Chambers 39 Essex do loads and loads of free content. We deliver loads of free content. All of the ones that we delivered through January are available on our our website and our YouTube channel. We in this area do those webinars for this group of people who do kind of fall into this grey area. So certainly have a look at them, because they, in all of those that I've watched and certainly I've delivered, we do give the actual references that you would need in order to support your own case. And while I've got the stand as such in this webinar, I just want to give a word of warning. And I know, Steve, we've touched on this before about parents who are using advocates. I'm not saying that all advocates are bad, certainly not saying that. But because advocates aren't regulated in the same way as solicitors and barristers are, just please do your research if you're using advocates, because certainly I have been in the position where parents have used advocates and actually ended up spending more than they would have used a solicitor or a barrister, and actually lost the case and had to go through it all again. So because they're not regulated in the same way, I would just say if you're going to be using somebody to represent your case, whether that's judicial review or an education tribunal, you should be asking questions such as, how many cases have they run before? Because every person can have a 100% success rate if they've only ever run one appeal. So that's always worth bearing in mind. Have they got anyone that could, give them a reference? All of these things just make me question, how much are they charging? What's that going to provide you with? It really concerns me when parents contact me telling me how much they're paying people to help them, and when there is so much fantastic free support. So, there's fantastic charities, IPSI, etc., hacks that I've mentioned, and all the free resources before spending lots of money. And certainly do your research if you are paying anyone to run an education tribunal, be it solicitors or otherwise.
I strongly agree with all that, Hayley. Thank you very much. I was just going to invite Alice. Yes, absolutely.
Just
Please,
very briefly. So 2 points. If you're going to tribunal and you don't qualify for support, or even if you do, but you're thinking about bringing on barrister at the end to represent you, do keep in mind that if you haven't had a solicitor on board, you can go what we call the direct access route. So maybe you've not been able to qualify for the support of a solicitor under legal aid, but you haven't been able to afford a solicitor and you've been managing the papers yourself. In some of those cases, you can directly access a barrister who can do come in and just do the advocacy at the end. And if you feel capable of kind of drawing together the paperwork and handling things with the tribunal, that can be an option that can save some money if you're concerned about that. The only other thing I would say is that there's a very big difference between running a tribunal on your own and trying to run a judicial review on your own. The big one being costs consequences. So if you lose in the tribunal, you're not going to be ordered to pay the other side's costs. If you lose a judicial review, you can and probably will be ordered to pay the local authorities costs, which could be thousands of dollars. So if you're legally aided, you probably won't have to do that, almost certainly won't. I generally wouldn't advise anyone who's not legally aided to launch a judicial review just because of that lack of cost protection. You certainly would want to take legal advice. So please don't go away and lodge a judicial review claim without taking advice about the potential cost consequences.
Yeah, absolutely, Alice. And on that point, one of the things you finally wanted to ask live was, is there a template letter for pre-action protocol letters? Is essentially your point, well, you really need a solicitor to help you anyway.
Yeah, I wouldn't. I know that there's a desire for templates. I wouldn't be comfortable sending one out because I don't work off a template. The facts of any given case are going to be very specific. And again, I've seen and heard of cases where a pre-action protocol letter was sent out throwing everything in, and actually didn't help the situation, made it worse. So just having that preliminary bit of advice, and again, I know SOSN can do that relatively cheaply, and there are other options. I think it is really worth getting right, because as we've said, most of these cases, once you get a stern legal letter from someone who's serious, often the local authority will capitulate and things, although not quickly necessarily, but hopefully things will start moving in the right direction. It's worth the investment. It'll probably save, if you can afford it, probably save time. And if you can't afford it, do, as I say, get in touch with some of the charities, because they often are willing to help as far as they can.
Absolutely, yes. Just two things that come in I wanted to flag and pick up. First of all, some questions. What did you mean by direct access barrister? So
Sorry.
Just to be clear about that. No, it's a phrase that is relatively new, of course. So barristers, including Alice and I, can be instructed directly by members of the public now in certain cases. Obviously, our capacity to do that is very limited because we are individuals, whereas solicitors work in firms. And so the vast majority of cases will be brought with solicitors on board, but it is an option in certain cases. The other thing to mention as well, and this goes to a point that was raised about whether you can get exceptional funding for representation in the tribunal, which we'll perhaps ask Gregg about, but also very junior barristers will often represent very cheaply, frankly, in the tribunal. So if you've got a solicitor helping you with legal help, it may well be possible to get very cheap representation for the hearing itself. People shouldn't be having to go into tribunals on their own, particularly against local authorities who've got representation. But Gregg, there was a specific question about exceptional case funding for representation in the tribunal. Was that something you've ever had to look at?
Thank you, Steve. And I saw one of the questions, and apologies, it wasn't in my initial sort of quick response.
We only had 10 minutes. That's nothing to apologise for.
Anyway, I appreciate, even by saying that, I'm eating into further time. So yes, I have made, or rather we as CCLC have made, an exceptional case funding application, which was successful. I'm aware that other law firms have also made that application, and that's also been successful. My understanding is that the first word, exceptional, would need to bite, really, because the tribunal being, or supposedly being, that parent, models itself on that parent friendly, being able to advocate within the tribunal as a parent, and whether or not people agree with that, I understand that point of view. I've also made another application which has been refused, and it was actually refused on the day of the hearing, but the barrister in question very kindly undertook that pro bono in any event. So there has been some success. There has been some success from other law firms as well, but it would need to really highlight to the legal aid agency under the statement of case as to why it is an exceptional reason. And that's probably a little bit too detailed for me to get into.
Yeah, I think so. But thank you. That's very helpful in principle. I'm conscious that we're coming towards the end of the time available, but there's a very important theme of questions I wanted to put to Hayley, if that's okay, Hayley, which is about who represents, and in particular around young people. And of course, the Mental Capacity Act applies from 16. And so are young people expected to bring their own claims in the tribunal and or judicial reviews? Can parents still bring appeals or JRs on their behalf? What's your take on those kinds of issues, please?
Sorry, Steve, you broke up there, but hopefully I've heard you okay. So a child, if it was about lodging a tribunal claim, a child can bring their own claim over the age of 16. So it's a child or the young person's appeal in the tribunal. They can bring their own claim, and they are actually encouraged, particularly by the tribunal, who actually are being quite creative in terms of listening to the young person, listening to the young person's views. They're even doing kind of links to YouTube channels, particularly if children are into kind of that way of expressing their views, and doing little videos for the tribunal. And they're really trying to get on board with kind of private YouTube links and any way that the child can be encouraged to actually participate, which I think is really encouraging. They can still have their parents' support. Certainly they don't have to run, it's a lot to expect of a young person to run their own appeal in the tribunal. They can still have the support of their parents if they wish to do so, and lots of young people do that, but many tribunal panels will still want to hear from the young person in any event. And I know you didn't ask me this, Steve, but I actually just saw when I was scrolling through, another parent had asked, actually, do you need deputyship to run a case in the tribunal? That's not the case. Deputyship is one of my specialist areas, and it's something that I would advise any parent asks for advice on before applying, because it is only required in certain circumstances. Certainly, if your young person lacks capacity, you can bring the tribunal claim as the alternative person without actually having to have a deputyship. So you don't need a deputyship even if that young person is lacking in capacity. I won't go into the depths of capacity. Generally, this is where it's accepted that this young person lacks capacity. But you don't need a deputyship to run a tribunal case. Certainly not. That's not the case. Steve, if I may, because I don't want Tanya to miss it, because I'm being a message to make sure that somebody covers it before we dial off, and I don't want to make sure we miss it, obviously being on their webinar. Tanya's actually asked, please can we just make sure somebody reiterates what to do if your child isn't allowed back. So as you've got off so lightly, Steve, I'll fire that one back at you and just make sure that we cover
Thank you very much.
If children aren't allowed back into school, what we do. So that's covered for you, Tanya.
Ring Hayley. No, I mean, in seriousness, though, of course, it is very concerning both ways, I think. So first of all, what do you do if the child is not allowed back in school? Well, it's crystal clear, as Alice made at the outset, that from the 8th of March, all children should be back in school. And of course, if the child in the HC plan, that is already the case. So the schools must be able to facilitate children's return. And the answer will be, if necessary, that either the local authority and or the school will need to be sent legal correspondence. Now, of course, hopefully you can avoid the need to do that through discussion. And one of the points that I wanted to flag from the questions was involving the Independent Advice and Support Service, the SENDIAS, as well. So there are various agencies that can help, local advocacy agencies, the SENDIAS and so on. Don't spend too much time, I would suggest, on those issues, and certainly don't feel like everything has to go through a complaints process first. Children have a right to be educated, and if they're being denied the right to education, then that's a legal issue that people should be getting advice on. On the other hand, we've got questions about, well, what happens if we don't want the child to go out to school because we don't think it's safe? I think those are really difficult issues. I don't know if Alice has got any particular thoughts on how to manage that situation. There were several other questions about attendance codes, for example, Alice, that we've spoken about in previous webinars as well, where parents feel that it's not safe for them to go back to school. Essentially, can parents keep children off school as of the 8th of March, or do they have to be sent back?
So my current reading of the guidance, I think two things. One, for the first sort of time, it's been clear that for vulnerable children, and that includes children with education, health and care plans during the national lockdown. So at the present time, if parent decides not to send a child or young person to school, then generally speaking, that should not be marked as an unauthorized absence, and the schools should be being flexible about that. So that's useful if the school is already saying, you know, perhaps you've not been sending your child to school and the school's been putting pressure on you, that there is guidance that suggests that that's not valid. On the other hand, it does appear that from the 8th of March, a return to sort of more normal marking of absences is going to occur. And I would suggest that you do look at the guidance that the government has produced, which includes content on attendance and marking of absences. I think the first thing that you should be doing is engaging in discussion with the school and setting out quite clearly your concerns, and particularly if there is a medical basis, if you have a letter from a doctor or something like that, and just seeing if the school are willing to be reasonable. It seems that it's very variable. Some schools are very happy having had discussions with parents to reach a decision and then not to record unauthorized absences. Others are being real sticklers, and at that point I would suggest that you seek legal advice, because there can be very real consequences if there's a string of unauthorized absences marked down. But I think your first port of call should be opening a conversation with the school and trying to sound out what their position is on absences from school for vulnerable children.
Steve, just to cut in, if I may, just to in case any parents.
Yeah,
oh, sorry. I was just going to say, again, being prompted by Tanya, who keeps me in order over on the legal column on SNJ. She wanted just to reiterate, in case parents have missed it, that if provision of Section F of an EHC plan isn't in place when children return, what they can do about it. And essentially, I think we're all agreed in the fact that that should be the sending of a Preaction protocol letter if you obviously have available private funds, or if you have access to legal help, as Gregg has so helpfully detailed for everybody today. I think it's really important that parents know the different avenues open to them, because not everybody will be able to afford to send a Preaction privately. But certainly in the theme of the comments, there are parents who have obviously tried to send the letter directly themselves and are saying that they're just being ignored. And that is what we see quite often, because it doesn't come with the threat of a judicial review following. because it hasn't gone on some headed note paper, the local authority do often disregard it, and that often is the case. So if you can't afford private means, then certainly do go check out Coram, the likes of Gregg, who will be able to support you if you do fall into that bracket. But there is a recourse if that provision isn't being delivered, and it must be being delivered as it should have been from September. I just wanted to cover that for Tanya.
Thank you very much, Hayley. Can I ask the panel another really interesting question, I think, which is an obvious one that arises from the pandemic and lockdown and the missed education that all children have experienced, but in particular, we know, sadly, disproportionately children with SEND. What are the opportunities, do you think, first of all, just generally to extend education for children to repeat years at school? But the more specific question that's being asked is, could an EHC plan go beyond 25 in that situation? Could there be another year of an EHC plan up to 26 if, in the event that the child, for example, the young person would have been missed a whole year of college? Does anyone want to answer either of those questions? The easy one or the hard one are both available.
Silence,
Go on, Alice.
Steve.
In terms of missed education, I mean, I think there have been some other questions as well about what do we do about transitions into school and all of that. So again, I just keep flagging you back to that guidance, and if you Google online or look at the links in the PowerPoints when we put them up, there's some helpful content there about making sure that any transition back to school is supported by social stories if that's necessary and so forth. And it does seem that there will be scope, and again, this might be in the annual review process, for example, to be discussing the potential to be repeating years or putting off phase transfers if that's appropriate. And again, I think a pragmatic approach is just to start a conversation with the school and with the local authority and see where that goes. And if there is resistance and disagreement about what's appropriate, then to seek specific legal advice. Now, that's not a legal answer. I can't put my finger on a legal entitlement, but certainly if a child's needs are such that they couldn't be met if they were forced through into the next year of school, I think you'd have a fairly solid basis for arguing that, you know, the provision set out for them shouldn't be pushing them through into a phase of school they're not ready for. I believe that Steve, you may in fact be the expert on the room in these questions, so perhaps I
think it's also the older category, isn't it, that's going to be affected the most here. It's going to be this is really directed for the young people whose EHC plans go up to the age of 25 and parents questioning whether they can be extended. I don't necessarily think we have any challenges to that unless I've missed it at the moment, just because obviously it is so new. I guess the question around that would be how we establish that. Really, it's a harder one than I think for younger children, and also the fact that there's the unknowing of how much catch up can be delivered. Certainly, it is possible to hold children back, not with all children, but it is possible in certain circumstances. But this is really going to be a catalyst for those young people on EHC plans who are in that kind of 24-25 category. I think that's where this question is originating from, unless I've misunderstood it. It's that category too.
That's right, Hayley. Two thoughts from me. First of all, I think this goes very neatly to the duties to make reasonable adjustments, and it's very important to keep in mind, and it's quite confusing really, that there are two sets of legal duties sitting alongside each other here. There's all the duties under the Children and Families Act, including the best endeavours duty on schools and colleges that Alice mentioned, and the EHC plan duties. And then alongside that, there's all the duties under the Equality Act, because the vast majority of children who have SEN will also be disabled children and have the protections of the Equality Act, including the duty to make reasonable adjustments to policies, provisions, criteria and practices. And so the reason I think that's relevant is that the way in which children progress through a school is a practice, isn't it? It's the moving up every year is a PCP in the jargon, which is capable of being adjusted, and that would be true for colleges as well. But on the specific question, my understanding is, and this is paragraph 9.207 of the code, that EHC plans can run, in the case of a young person who reaches their 25th birthday before their course has ended, it can be maintained until the end of the academic year in which they turn 25, or the day the apprenticeship or course ends, or the day before their 26th birthday if later. So as I understand it, at the moment, unless the government changes the law, EHC plans cannot continue once the young person has turned 26. So there is, as I understand it, a hard cutoff. But something I meant to stress at the beginning of the talk was that we're not giving any advice today. We are merely discussing some very interesting issues. So I do apologise if I've got that wrong, but you can't hold me to account for it because it's just a webinar. So one other thing to deal with before we wrap up is a number of requests, Greg, for your list of face-to-face legal providers. And I've been looking for the chat function to wonder if you just write it in, but I can't find it. So probably the best thing for you to do is just read them out. If you wouldn't mind giving people the names for the 8 face-to-face providers, please.
Absolutely. Thank you, Steve. I need to apologise. I saw the chat function after I delivered my talk and I was scrolling through it and I did see the repeated question. I have tried to answer that once, but you're absolutely right in terms of accessing that. So I think I would need to stress that my understanding is that of these 8 providers, 6, although all 8 offer face-to-face appointments, it may be for the face-to-face it's subject to capacity. And if in fact you are able to contact that law firm and the response is that they don't have capacity at the moment, then you would come back through that civil legal advice line and have that telephone advice system. So you're not going to be left high and dry, so to speak, if the face-to-face isn't available. But they are Bailey Wright and Co, Cartwright King, Coram Children's Legal Centre, so CCS. Thanks. GT Stewart, Irwin Mitchell, NR Legal Solicitors, Simpson Miller, and Sinclair's Law. So it's where it's your, in practical terms, and sorry to railroad this, if and when you phone up for civil legal advice, one of the first things that should happen, hopefully, is that you would be asked if you would want that face-to-face appointment, and you would then be given your 3 most local providers, if you like, subject to where you live. So they would look at your postcode and then say, well, this law firm is X amount of miles away, then the next one is X amount of miles away. So hopefully that's helped, but apologies, I haven't been able to answer your question.
It is very helpful, Greg. Thank you very much. And I should stress, of course, that we could literally go on all night about this, and we aren't going to, for very obvious reasons. But this is just one of the many fabulous products that Special Needs Jungle offers by way of information resources for this community, the SEND community. And I'm very pleased to now hand back to Tanya and Renata to perhaps just wrap up the talk, reflect on anything that they've heard tonight, and suggest where we might go next with all of this as well. So back over to you, and thank you both very much for putting this on for us.
Well, thank you all for spending your time with us this evening. It's been an incredibly informative session. There's been so much information there. That's why I asked you to reiterate those points at the end, because you know how you can just lose a thread for a second and then everything is gone. So what we're going to do is get this webinar, the recording, put it on our YouTube channel, put it out as a post on Special Needs Jungle. And also all those questions who haven't been answered, I'm hoping that the team will be able to, I've tried to grab them as well, so we can try and answer as many of them as possible. I've also taken a copy of the ones that you answered in the chat as well, and we will be putting those out on Special Needs Jungle as well. So thank you very much, everybody. Renata.
Yeah, a huge thank you to all of our 4 legal experts, Gregg from Coram Children's Legal Centre, Hayley, our wonderful legal columnist from Sen Legal, Alice from Dirty Street Chambers, and of course Steve from 39 Essex Chambers. We couldn't do it without you, and we really, really appreciate you giving up your time for free to help our parents out. And as Tanya said, we will be putting this up on YouTube. We will also share Alice's great slides. So if you didn't manage to write down all the information, don't worry, we'll get all the information up for you. And if you've enjoyed this evening and if you found it helpful, please do consider making a donation. We are volunteers and we put all the money given to us towards doing more events like this to help you out. So every penny is appreciated. And thanks ever so much for joining us tonight, and we hope it's been helpful.
Thank you, everybody.
Thanks. Good evening. Bye-bye.
Bye.